Hi, it's Guy DiMartino. I am a Northwest Indiana probate lawyer, and today I'd like to talk a little bit about an issue that we see happens pretty often when the personal representative lives out of state. But before I explain the situation, if you ever have any questions regarding a Northwest Indiana probate matter, you can always reach out to me at indianaestatemeeting.com. I'd be more than happy to give you a few moments and try to answer your questions. So here is the situation. A parent dies and their kid lives in another state, say New York or California or Florida, and they are appointed the personal representative for the estate. Now, you can do that. You can have an out-of-state personal representative, but you have to appoint a registered agent in the state. And typically for my clients, I become the registered agent. So then I would be able to get service of process should anybody file a claim or a lawsuit against the estate on behalf of the personal representative. That's the first hurdle. Second hurdle has to do with bank accounts. So many banks, well, pretty much all banks, will actually require the personal representative to go into the branch and open up an estate bank account. You need a copy of the letters testamentary or the letters of administration, copy of the tax ID number for the estate, which we get from the IRS, and then they will open the estate bank account. However, many times the kids come into town, they take care of business, and then they leave town and they go home. And by the time the estate is opened, and by the time the letters are administered and given, they are back home. Now, many banks, well, again, pretty much all banks out of state, for instance, the law in Indiana requires the estate bank account to be in an Indiana bank. So one of the ways that we can handle it is we can go to a national bank, say a BOA if you have one in your area, or a Fifth Third, or PNC, or Chase Bank. However, many times those banks will not allow you to open the account at your local branch where you live out of state because it's going to require some type of information from the court. Typically, we have to go out to the court and we have to ask the court permission to open an out-of-state bank account, and we have to get a court order. Now, the rub is this. Some judges in some counties will issue that type of order. Other judges are a little more of a stickler and will not issue that type of order, and that would require the personal representative to come back to Indiana just to open a bank account unless we can arrange some type of power of attorney or something like that to go ahead and open the bank account. So that's a hurdle that you have to be aware of, that you might have to come back to the state of Indiana to open a bank account if the judge will not give you an order. Typically, the way that I phrase the order is, look, we are going to a national bank. There are local branches of this bank. The judge, if there's a problem, your subpoena can be served on the local branch of the bank within the jurisdiction of Indiana, and we should be able to get this information. Some judges will buy it, some judges will not. If you have any questions about a Northwest Indiana probate matter, you can always reach out to me. I am Guy DiMartino. Have yourself a great day.